Hello everyone, I'm attorney and professor Kirk Angel, and I want to welcome you to this, our sixth mini lecture on topics in employment law. Today we're going to talk briefly about the Fair Labor Standards Act of 1938. However, before we get into our topic, I want to remind you that this mini lecture is designed to be educational only and is not meant to be legal advice. If you're facing a serious issue at work, you should contact an attorney who is licensed in your jurisdiction. The Fair Labor Standards Act of 1938, often referred to as the FLSA, was really the first generally applicable employment law that was passed by the federal government. This contained a number of concepts that over the years have become key to our idea of wage and hour laws in the United States, and key concepts from this flowed into our collective consciousness, and now almost everyone, and certainly workers, are familiar with these concepts. Let's talk about what those concepts are. The first concept from the Fair Labor Standards Act was a concept of a 40-hour work week. Now, I'm sure many of you are laughing out there because you don't have a 40-hour work week, but it introduced the idea that you would have a 40-hour work week at that point in time for a more manufacturing-based economy rather than our service-based economy today. And along with that came another concept, which is a concept of overtime. So if you have an employee who works 40 hours in a week, then generally the idea was that employee would be entitled to overtime pay for any hours in excess of 40 hours per week. Along with that same concept came the idea that we would pay, or an employer would pay, overtime at a rate equal to 1.5 times the employee's normal rate. Whatever the hourly rate was for the 40 hours, it would be 1.5 times that for the overtime pay. In addition to those concepts, the Fair Labor Standards Act introduced the concept of a minimum wage. So for the first time ever, thanks to the federal government in 1938, we had an idea that an employee should be paid at the very least a minimum amount. That amount has changed throughout the years, and Congress changes it on occasion, and it's meant simply to be a floor. In other words, the employer cannot pay less than that, but the employer can certainly pay more if they want to. The final concept that we got from the Fair Labor Standards Act, the FLSA, was the concept that children should not work for the most part, especially not in dangerous occupations. The Fair Labor Standards Act did in fact contain child labor provisions. And the provisions, although they somewhat vary, are generally the following, which is generally children under the age of 16 should not work, and children between the age of 16 and 18 should not work in dangerous jobs or dangerous occupation. From that portion of the Fair Labor Standards Act came the concept of getting work permits for children who do want to work under the age of 18 or between the ages of 16 and 18, and they would need a work permit to do that, to verify that the child is not working in a dangerous job. Again, I'm attorney and professor Kirk Angel, and thank you.